All right, so we're here on two cases, Jill Bong versus Douglas County School District 15, 25 CV 59501, and then 26 CV 00462. And so, do we have Mr. Mersereau on the line?
I am here, Your Honor. Good afternoon.
All right, and Ms. Bong, are you here?
Yes, Your Honor.
Okay. And so, Mr. Mersereau, what do we have set for today?
Well, I believe technically we have two things, Your Honor. One would be the motion to dismiss in the 59501 case, which is the case that Judge Johnson first ruled on and then later recused herself and transferred the case to this court. And then the other matter is the 26 CV 00462. And there are at least one and potentially two matters in that case. One is the motion to dismiss my counterclaim, which Ms. Bong filed. The other matter is the motion for summary judgment that I filed that is fully briefed and, in my view, should be heard today, but of course, plaintiff will disagree with that.
And wasn't one of these just an objection as to the form of the judgment?
Well, that depends, Your Honor. In 59501, the sequence of events went like this. Judge Johnson ruled on my motion to dismiss, and granted the motion to dismiss, and also found specifically that there was no objectively reasonable basis for that claim. After that happened, the plaintiff raised the objection that she had not been afforded the opportunity to disqualify Judge Johnson. And Judge Johnson then wrote an email to the parties saying, while I have already ruled on the motion to dismiss, Ms. Bong is correct that I did not give her an opportunity to automatically disqualify me or disqualify her without cause, and so transferred the case to her. I don't know if the court has seen that email, but it's not 100% clear to me whether she intended, well, let me just read you from the email, Your Honor, which was sent on March 26th. She says, Ms. Bong has a point that she was not afforded an opportunity to affidavit me before the decision was made. I am reassigning this case to Judge Hoddle effective today. Judge Hoddle will then render his own decision in this case. So I'm not 100% clear, to be honest with you, whether or not she intended you to go back and rule on the motion to dismiss again, or whether we're now just looking at the judgment, the form of judgment.
No, I take that as we have to redo the motion again. So I will rule on that motion. Do the parties want to be heard on that?
Not at this time, Your Honor.
I don't have anything to add to what I filed, Your Honor. I can outline it very simply. This is simply a copy and paste job. There was another case, namely 23 CV 45433, that is identical to this case. Same public records request, same relief asked for, same allegations made. Summary judgment was filed by me against that claim. It was granted. Judgment was entered in May of 2024. That case is closed. This case, the 59501 case, literally was a copy and paste of those same allegations, same public records request. And so under the claim preclusion doctrine and under Rule 21, it should be dismissed.
All right. And Ms. Bong, anything other than your written response?
I don't believe so. I'll just recap. Rule 21 does not allow for claim preclusion or res judicata defenses in that claim, in that defense. For that reason alone, that the MTD should be denied. And also the respondent did not certify that he had conferred with me on the claim preclusion as required by UTCR 5.010, I believe. And for that reason alone, the motion to dismiss should be denied as well.
So even with those technical defenses that you're bringing before the court, I mean, if substantially he's correct, you're saying this case should still be able to move forward?
I'm saying that at this point in time, he should not be allowed to raise the claim preclusion or res judicata at this technical stage.
And Mr. Mersereau?
Your Honor, frankly, I don't recall what the conferral was on this motion. This was, I believe on November or December that it was filed, quite a while ago. But the court is correct. I mean, substantively, this case should not exist. It is a complete waste of everyone's time and resources. And that's why I've asked for fees and a finding by this court that this case was effectively frivolous, that it's not warranted by existing law. If I need to probably go back and look at the pleadings to see what my conferral certification was, and if we need to confer, I will confer. But at the end of the day, this case is not going anywhere, or should not, in my view.
And so based on what I've heard, reviewing all the written documentation filed by both sides, I am going to grant the motion to dismiss.
Thank you, Your Honor.
And so that will conclude that. And then let's move to the other case.
Yes, Your Honor. So the counterclaim does not claim frivolous litigation is not a cognizable cause of action, so it should be dismissed as pleaded. I also object to any attempt by respondent to cure its lack of response through a new oral argument today. I also object to folding summary judgment into this hearing. That motion was filed later, and I have not had the full oral CP 47 response period, and there are still disputed facts. Even in an expedited public records case, or CP 47 still governs judgment, and ORS 192.431 places the burden on the public body to sustain its action. In Bong v. Douglas ESD, the appellate court ruled that the public body must provide adequate support or evidence to bear its burden to sustain its action, and it has not done so.
So what do you believe is the genuine issue of material fact?
In this case, the respondent, I allege that the respondent did not respond to my public records request. Instead, Mr. Mersereau responded to it, and they claim that satisfies the public body's response to the public records request. However, there's no indication that Mr. Mersereau is the public body itself, which is required to respond to the public records request, not a third party, Your Honor.
And Mr. Mersereau?
I'm the lawyer for the school district, Your Honor. That's what it boils down to. Mr. LaFontaine is the superintendent of the school district. Filed with my motion is his declaration saying, I am the lawyer for the school district. I am the agent of the school district, and thereby a part of it, my response to the public records request is the district's response. And the bigger point, of course, is that Ms. Bong is not being honest with this court when she files a case saying she never got a response. She did get a response, and she knows that very well because she attached that same response to a complaint that she emailed to a number of people in the state, including some of my other clients. So this, again, is a case where I believe there is no objectively reasonable basis to have it filed, and I believe defendant is entitled to its fees, Your Honor.
And so, Ms. Bong, if you're requesting more time to respond, I will give you that, but is that what you're requesting?
Well, Your Honor, I'm actually opposing the summary judgment because there are material issues of fact as to whether Mr. Mersereau's response is actually a response from the public body. And for that, I need discovery, Your Honor.
I don't believe any.
Is the response attached?
The response was Mr. Mersereau, Your Honor, not from the school.
Right, but I'm saying, Mr. Mersereau, so is that attached to any of the documents that the court can consider?
Yes, that's in the summary judgment paperwork, Your Honor. It's attached as an exhibit to my declaration. And also attached to that declaration is the email that Ms. Bong sent out a year after this public records request occurred, attaching my response. You can see I responded on behalf of the school district less than 24 hours after the public records request was made. I followed the statutory protocols, checked off every box that needs to be checked, gave her a reasonable fee estimate, and we never received a response. Never received the fee, never received a waiver request. Under the statute, after 60 days runs, the request is closed if the requester does not respond. And so there's just no claim here under the Public Records Act, Your Honor.
Your Honor, may I say something?
What? Yes, go ahead, Ms. Bong.
By this argument, Your Honor, if the school district were to say they forwarded the email to a parent or a neighbor or a UPS guy and the UPS guy responded, does that mean that the public body responded? It does not, Your Honor. They're not the public body that is required to respond.
Oh, it's different when someone's an attorney who's representing them.
There was no
So
indication that he was representing them, Your Honor.
Which exhibit are you referring to, Mr. Mersereau? And I'm looking at the declaration.
It's Exhibit 1, Your Honor, to my declaration in support of the summary judgment motion is the email exchange that occurred in April of 24. And then Exhibit 2, that's just one page. And then Exhibit 2 is the 3-page email that Ms. Bong sent out a year later, which attaches the same email from April 24.
All right, I must be looking at the wrong declaration because the one I have starts out with that your counsel that you filed at least 10 cases against defendant, or plaintiff has filed at least 10 cases against defendant, and it describes some of those cases.
I believe that's my motion in the 59501 case, Your Honor.
Oh, yes. Okay. Yep. All right. I'm looking
yeah.
at the wrong case. Thank you. So, and so when was the declaration filed? I'm just having a problem finding it, but.
My declaration?
Yes.
That was, let's see, March 30. It was accepted on March 31.
And this is 25 CV 53228.
No, sorry, Your Honor. That's another case that I believe is before you, but we're in 26 CV 00462.
Okay. And so that, I think the 25 CV 53228, is that the one where it was an objection to the form of the order based on my ruling?
Yes, correct. And I believe that order is in your queue, Your Honor, for signature.
It is. It is. All right. So let me get back to. All right. 26 CV 00462. Excuse me. And so you're referring to the April 25th email where you represent Days Creek for the purpose of this public records request.
That's correct, Your Honor. And also in the summary judgment record is a declaration of the superintendent of the school district, which says, I am the lawyer for the school district.
Right.
Your Honor, that doesn't say lawyer for what? For this proceeding, for responding to the public records request, for what? It doesn't say.
Well, the lawyer is representing, I represent Days Creek for purposes of this public records request.
That's the agent's assertion, Your Honor. I never received any clarification from the public body or the principal, Your Honor.
And so I guess this is the case where you're asking for the appropriate timelines to reply.
Yes, and also additional timeline to request discovery, Your Honor.
What do you need? Well,
it's in the summary judgment response, Your Honor. It's quite a few items that I need from the respondent, including the vendor contracts and stuff, to show that Days Creek did indeed hire Mr. Mersereau to act as public records custodian.
so I'm not going to extend the timelines. What I have before the court is the superintendent saying he's the lawyer for the public records request, and the lawyer saying he's the representative for the public records request. And so I don't believe that more discovery is going to ferret any information out that could be pertinent to the court. But I will allow you time to respond that are laid out in the statutes. And so when is that timeline up?
I believe it's at least 20 days, and then I can request additional time for discovery, Your Honor. And that would be plus 30 days from the RFPs.
Your Honor, I understand if the court wants to give Ms. Bong the 20 days, which would be, I believe, April 21 would be the response date. But I would point out, number one, that she's already responded substantively. And number two, I don't think any additional time beyond that 20 days for discovery would be appropriate for the reasons the court has just mentioned.
Right. I'll give her the 20 days. And so it'll be April 21st. Are the parties available on that date? I mean, are you going to want time to respond to that, Mr. Mersereau?
Possibly, but not much.
Okay.
We could do it later that week.
That won't work for the court, but we could do it. How about April 30 at 8:30?
I can make that work, Your Honor.
That would be fine, Your Honor.
All right. And so we'll hear the rest of the summary judgment motion at that time when Ms. Bong has the appropriate time to respond. And then moving to the third case that's not on the docket, which I thought, should be, is just the objection in regards to the form of the judgment and whether or not it should be with prejudice or without prejudice. And so, Ms. Bong, you may go ahead.
Please, Your Honor.
Yes. And let me go ahead.
Yes, it should be without prejudice, Your Honor, because the claims have not been adjudicated, and a Mandamus case is discretionary by the court. The court has decided that it will not rule on that, so any claims that are tied to it should be dismissed without prejudice.
Mr. Mersereau?
It should be with prejudice, Your Honor, for at least three different reasons. Number one, Mandamus is not available in public records cases as a matter of law. This is the Jordan v. Motor Vehicles case at 98 ORAP 511 that says plaintiffs in Public Records Act cases have plain, speedy, and adequate statutory remedies and therefore can't proceed by mandamus. The other reason is that these claims have already been adjudicated in other cases. Again, this case relates back to two earlier cases, 23 CV 45433 and 25 CV 20641, in which summary judgment and a motion to dismiss, respectively, were granted. So she's precluded there. And beyond that, it's untimely. Laches applies in mandamus claims because, of course, these are equitable claims. Laches requires that a mandamus proceeding be filed within the statutory time for an appeal, so 30 days. This case or that case was filed in September of 2025. The Public Records Act, their public records requests, the latest one of those was May of 2025. So it's untimely. But this is all laid out in my motion to dismiss in that case. I just don't think there's any way to save this case, Your Honor. Mandamus, in the context of public records, just does not exist.
And so I am going to dismiss it with prejudice. And so I'm going to sign the order that was presented in my queue. And I'm signing that right now. And so is there any other matters that we need to take care of today?
I don't believe so. Thank you, Your Honor.
All right.
Thank you, Your
So
Honor.
we'll see you at the end of April.
Thank you.
Thank you.